Welcome to the O'Connor Elder Law channel. I'm your host, Melissa O'Connor. I'm a Florida-based elder law attorney who does estate planning, focusing on long-term care needs, commonly referred to as Medicaid planning, and I do probate, and I do it well. Today, I wanted to talk to you about what it takes to set up a guardianship in Florida. But before I do, I wanted to invite you to schedule a free strategy session with me at eldermeeting.com. So it's common for me to receive calls from people who either know that they need to petition for guardianship for their loved one or don't realize that they need a guardianship but think that they're able to put in place a durable power of attorney. And upon further discussion with their loved one, we realize the time for implementing that sort of protection has passed, and their ability to engage in planning due to cognitive decline is just not possible because they don't understand what's being asked of them. They're not oriented, and it's simply just not something that we can properly do. And so the only thing that the family is left with is a guardianship proceeding, so that way they are able to handle their loved one's affairs. Many times they come to me when they realize that they need access to some sort of banking account or otherwise need to be able to sign contracts for them to be able to live in an assisted living type facility, and their loved one just doesn't have the ability to handle those decisions on their own. So that's when we need to start talking about guardianship, and it can be an overwhelming conversation, and many people don't understand what it really entails. And in Florida, what it entails is actually two lawsuits. They're two separate cases that we open in the courthouse in the county in which the person who would be the ward, meaning the person who we are seeking to have a guardian appointed for, the county where they reside. That's where we would petition to open these two separate cases. One case would be opened in the mental health case, and it involves petitioning for a determination of incapacity, where we ask the court to appoint a panel of 3 members to evaluate their loved one and determine what capacity that they have or don't have. And simultaneously with that, we would file to open a separate case, and that would be a guardianship case in which we ask I would ask for my client to be appointed the guardian of their loved one. So usually it's the person who petitioned. They then seek to be appointed the guardian of their loved one that they believe is incapacitated. And so the process would go through where the panel would come back with their recommendations. Many times they're very consistent. Sometimes you get a one-off, and it would either be that they fully have capacity and this is not needed, or that there's limited capacity, meaning that there's certain types of rights that the person is able to maintain. Most commonly, it's the right to vote, the right to determine where they live, the right to determine who they socialize with. But the right to contract and handle their money might be, they might not be able to have those capabilities anymore. So just basically they have limited capacity. Or it might come back saying that they recommend a full plenary guardianship, meaning they have no capacity to handle any of their affairs. And once that determination is made, then the court will then move forward with the petition for guardianship in the separate case. They have 2 separate case numbers. And at that time, then they will evaluate the petition for guardianship. And you would be appointed guardian after having passed the background check, undergoing educational requirements, taking the necessary oaths. And if you meet all the satisfactory requirements, then the court can appoint you to be the guardian. This is usually the time that if there was going to be a dispute, that there is, other family members and interested persons would be able to say, no, I don't think you'd make a good guardian. I'd be a better guardian. Or this person would be better appropriately served by a professional guardian. This is where the cases usually open up for litigation if families do not agree, and it can become a very expensive and emotionally tolling exercise. It is best when families agree, and many times The court will refer parties to mediation in an effort to resolve it as a family, but if it can't be resolved, then the court will rule. And then ultimately somebody will be appointed the guardian of the ward, and then they will need to take control over the assets, place them in a restricted account, do accounting, and basically have to respond to the court until such time the person is declared to now have capacity, meaning they get better, or until they pass away. So that's just guardianship in a nutshell. There's a lot more to it, but at least it gives you a flavor as to the procedure and steps of guardianship here in Florida. If it is something that you think your family might be facing, I recommend that you reach out to an elder law attorney to help guide you through the process. It's not necessarily one that you can travel alone. If you'd like to schedule a free strategy session with me, you're welcome to at eldermeeting.com. I hope that this information has been helpful to you. Thank you for joining me.